Welcome back to the afternoon session of our online conference on algorithmic bias and the EU non-discrimination policy. Our third panel will focus on the topic of algorithmic bias and law enforcement. Our first speaker on this topic is Caroline Meller-Hannich. She is a professor of civil law, civil procedure law, and commercial law at Martin Luther University Halle-Wittenberg in Germany. Her research focuses mainly on the topic of civil law and commercial law, as well as on German and international civil procedure law, with an emphasis on collective redress. In her most recent research, she asked the question whether class actions are a suitable procedural instrument for consumers' protection against AI system. Professor Meller-Hannich, the stage is yours.
Perhaps a human decision maker could have taken other perspectives into account. Now, it is certainly the case that discrimination and consumer harassment are prohibited, or at least regulated by a multitude of laws. Frederick and Raphael presented them earlier today. Just think of the German General Act of Equal Treatment or the regulations on the prerequisites of data protection, compliance scoring. However, there is relatively little AI-specific regulation in substantive law. I would like to come back to two laws, at least briefly. The General Data Protection Regulation, GDPR, gives a data subject the right not to be subjected to a decision based solely on automated processing, including profiling. So in principle, final decision-making AI should not be used. Admittedly, there are a number of exceptions which can be found here in the small print. It should be noted that special safeguards are necessary, especially when it falls to discriminatory decisions. Paragraph 4 of Article 22 provides for counter exceptions in this respect. And it refers to Article 9 of the GDPR, which I would like to introduce here briefly. Decisions explicitly related to fundamental rights and those that reveal certain highly personalized decisions should not be made. In this sense, we are discussing categories such as gender and political views, up to and including sexual orientation. So even if these are supposedly necessary for the implementation of the contract or the person concerned agrees, they should not become the basis for such decisions. It is clear, however, that in our two cases, a bias would not be the basis for such. These problems are not really concerned. Firstly, we do not know why the mobile phone contract is not to be granted, and whether the fact that someone is a single mother already falls into one of the categories of the GDPR is, at least in my eyes, unclear. As we know, the EU AI Act, already presented today, has also drafted a number of regulations for AI, which differ depending on the risk level. Incidentally, many of the risks I mentioned are found here in the high risk level, for example, concerning employment and contracts or lending. Two perspectives of the EU AI Act takes up can certainly be applied to our examples. In both cases, human oversight could be said to be lacking. Moreover, in the first example, it was clearly not apparent why the decision had been taken in the way it was. This is where the control of algorithms and their training data provided for by the EU legal framework seeks to remedy the situation. Jan Laurin mentioned that earlier today. Articles 14, 15, and 33 of the draft provide for control mechanisms at precisely this point. So how can the existing law and the existing substantive legal positions be enforced? The draft regulation itself only provides for enforcement by public authorities, like the Commission Nationale Informatique et Liberté, Félicien et Gaëtan presented earlier this day, or the non-discriminating ombudsman in Finland. This applies to both the European level and the national level. The idea is to combine ex ante and ex post control. It is important to note that the authorities should also have access to processes that are only documented internally. As far as private enforcement is concerned, we already have a number of collective actions that serve preventive or declaratory purposes or provide support in cases of discrimination. Many of these legal actions also have their origins in EU directives. I have listed regulations from the Injunction Act, the Disability Equality Act, and the General Equal Treatment Act. Regarding this, it can be seen that some of them are already there. However, many of these possibilities for legal action are not tailored to the specific machine learning problems. For example, the General Equal Treatment Act is not even defined as a consumer protection law in the context of the Injunction Directive. And the Model Declaratory Action, the German Musterfeststellungsklage, does not apply to labor law. And where lawsuits are possible, they rarely take place. The rulings obtained here by anti-discrimination associations can be counted on one hand. It must also be stated that these are not genuine lawsuits by association, but, as I said, lawsuits in which anti-discrimination associations support individual victims. At this point, by the way, academics have been calling for a specific anti-discrimination representative action for quite a long time. The introduction of claims for damages against AI discrimination is also being discussed in this respect. Will improvement be introduced in the near future? Indeed, a new directive on representative actions to protect the collective interests of consumers was adopted last November. It is to be implemented within the next year and a half, and the prominent and truly new feature of this directive is that it allows for an action by an association seeking damages, compensation. So in the areas where up to now only actions for injunctions were possible, actions for damages will also soon be possible. Incidentally, AI can also be used here in the fight against discriminatory AI. A register of complaints might be organized and managed autonomously by means of machine learning, regardless of whether an opt-in or opt-out system is chosen. A problem that should not be underestimated is, of course, that the new directive does not create any law claims on their own. It can only be used in areas where claims for damages currently already exist. However, it does have a fairly broad scope of application. Product liability and safety, unfair contract terms, financial services, competition law infringements, and other areas of law listed here are open to the new representative action. Here too, however, no AI-specific regulation is listed apart from geo-blocking. In this respect, there are definitely calls to introduce explicit claims for damages against algorithmic discrimination. In addition, the directive must be implemented in such a way that enforcement is able to also function in practice. In this context, it is in the hands of the implementing member states to enable a lean, effective, and rapid procedure. I would like to draw particular attention to one clear improvement brought about the new directive. It concerns Article 18 of the Directive on Representative Actions and the possibility for the use of evidence that may be in the hands of the defendant or a third party. We have already heard several times today that it is precisely the problems of presentation and burden of proof that prevent those affected from successfully enforcing their rights. The reversal of the burden of proof in the General Equal Treatment Act does not seem to be sufficient in this respect. Private enforcement is therefore not even attempted or initiated. The new directive, if successfully implemented, could remedy this situation. It obliges the defendant to disclose evidence. I'm very curious to know whether the next speaker thinks that this is already a threat for trade secrets. However, I think this is really an improvement brought by the new directive. I would like to briefly address the conceivable purely privately organized use of machine learning against discriminatory algorithms. Here, the registration of affected persons, their administration, and also the legal preliminary examination could certainly be carried out by intelligent systems. In this context, I would just like to point out that the Legal Services Act, which was amended in Germany just a few days ago, provides for a regulation specifically related to automated legal checks. In the case of one of the above-mentioned legal tech claims platforms rejecting a mandate, it must be informed whether the claim review was carried out in whole or in part by automated means. In conclusion, on the one hand, discrimination by machine learning is a mass occurrence with comparable facts and circumstances in which the individual victims are reluctant to sue for various rational reasons. Here, instruments of collective legal protection could be utilized to help, which could be used for the purpose of bundling and organization. The EU AI Act is, however, focused on public enforcement. On the other hand, neither the scope of the existing private legal enforcement mechanisms nor that of the future possibility to sue are specifically tailored to the dangers of discriminatory algorithms. Corresponding provisions such as certification standards would in any case have to be included in the scope of application of the new representative action. In this respect, official and private law enforcement must urgently complement each other. Thank you very much.